The last thing I want to talk about on Senate Bill 414 is Section 10, and this has to do with the legal orphan situation. And this is something that I could talk to you about for a couple hours, but I won't. Section 10 talks about the kid who the parents' rights have been terminated, or the parents have released and surrendered the child. We have a relinquishment. And that happened 6 months ago. Right now, in that circumstance, the agency has to send a notice to the court about that. Okay? The difference now is that when they send that notice to the court about that kid in that circumstance, the court must hold a permanency hearing within 30 days. The court must hold a permanency hearing within 30 days. Now, originally, I sort of inquired, so why do you want a permanency hearing? It seems to me that if you're trying to get to the bottom of the stalled adoption, permanency hearing isn't your best vehicle because you've got all these other findings to do. It seems to me like your best vehicle would actually be a CRB review, or maybe a review hearing. Come in and say, what's the problem with the adoption? What's holding this up? And the people who were behind this bill said, that's not the only question. It might not be a question of what's holding up the adoption. The question might be, is adoption still the best permanent plan for this child? And I thought about that because, look, what does a permanency hearing do? A permanency hearing decides what's the best permanent plan. Aside from all the other findings you make that are associated with a normal review hearing, a permanency hearing decides what's the best permanent plan for the child. And you do that according to the statute in a very rigid kind of way. The first thing you do is you ask yourself, can we return this child to the parents? That's the first thing you do. You eliminate that. Then you say, how about adoption? Is adoption the plan that's in the best interest of this child? No, you eliminate that. Then you can talk about a guardianship. Is this the best plan for this child? No, you eliminate that. Then you talk about planned permanent living arrangement. And you can't skip any of those steps according to the statute. Now, I'm not stupid. I look at the statistics on how long hearings take. We keep those statistics. I know there are 8-minute permanency hearings. So I know that in a permanency hearing, the judge is not looking, in an 8-minute permanency hearing, they're not looking at evidence about return home and then evidence about getting down and all that stuff. That's not happening. But here's the thing. 419b-476, the permanency hearing statute does not create an exception to going through these steps in every single permanency hearing. If a kid's been in permanent foster care for 5 years, the statute still says you go back and look at return to parent. And the court has to determine whether return to parent is the appropriate permanent plan. I mean, that's what the statute says. Regardless of what we do, that's what the statute says. Okay? There's no exception in there. Okay? Now, so here we are. We got this kid, not placed for adoption, right? No adoption proceedings begun. Neither of those two things. Kid's legally free. Now we're in a permanency hearing. Okay? We're going to have to go through this whole rigmarole.
So the judgment of termination, permanent commitment to DHS, is meaningless?
No, it's not. But it doesn't take away what the other statute says, 419b-76, about how you conduct a permanency hearing. I know where you're going, but just wait.
About return of parent, and there would be a legal parent.
That's right. Wait, just wait. I know, I feel your pain. I feel your pain, I feel your confusion. I've been through it, I've worked through it, and here's the deal. When you get a kid who's in that circumstance, this is what the situation is. If the kid gets placed for adoption or the kid has an adoption proceeding begin, then the kid's out of this group, okay? So it's not just kids who are not yet adopted. It's just kids for whom there's two definitions of adoptability, okay? One definition, kid's small, young, cute, not damaged, right? No siblings attached. That's an adoptable kid. Okay? The other definition of adoptable, kid's an unmade bed emotionally, completely damaged, totally weird off the wall. Somebody says, I'll adopt the kid. That makes the kid adoptable. And often, who is that? That is a foster parent. Okay? So the foster parent says, I'll adopt the kid. So the kid's adoptable. So now you've had a termination. The judge said the kid's adoptable because we have this placement. 2 weeks after the termination trial, the adopted parents die. Okay? Now you've got a kid with no prospect for adoption. Does this happen? Oh, yes, this happened. I see heads nodding. I had a case like that. Okay. Now, How many people in this room, you don't have to raise your hand, but how many people in this room have seen circumstances where you've got a kid who's been in this circumstance for a long, long time, and all of a sudden, mom, who 3 years ago at the termination trial, she weighed 82 pounds, and her teeth were falling out of her mouth and rattling on the table, right? 3 years later now, she weighs 230, and she's working at U.S. Bank as a teller supervisor, right? Doesn't happen very often, but it does happen. In the past, you know what? This has happened in the past. It's happened in this very county, where DHS has brought that mom into the judge and said, look. And the judge has vacated the termination judgment and reinstated this mom's parental rights. Okay? Now, doesn't get around much that goes on, but that has gone on a time or two in this county. And that's one of the things that this bill was aimed at doing, because in the original iteration of this bill, it put in the 419B76, the permanency hearing statute, it said in there that the judge had the power to vacate a termination at a permanency hearing. But then we looked at 419B923, which is the statute for vacating any judgment in a juvenile case, a dependency case, and we realized that there was nothing in 923 that precluded doing it already. So they took that piece out of the bill. You won't find anything in this bill about vacating termination judgments, but the lawyers are intending to do more of this. Now, that's really great. That's good. That's fine. But you know what? Here's the thing. Let's say that I'm a judge. Scary thought. I'm a judge. Many of you may know I actually do some pro tem judging, but I'm a judge. I'm in a permanency hearing, and I've got a situation where somebody's asking me to vacate the termination. I know I can do it. But I'm thinking to myself, that was a 7-day trial in this case. And a lot of witnesses and a lot of evidence. And some judge, a lot smarter than me, decided, by clear and convincing evidence, to terminate these parental rights. And it went to the Court of Appeals, and they said, okie dokie. And it went to the Supreme Court, and the Supreme Court says, we're not going to hear this. And it was finalized. Now me, by a preponderance of the evidence, in a permanency hearing, I'm going to undo all that? Okay. So we asked the legislature, we said, how about some guidance here for the court? What's going on, what the procedure is and why you can do this. Because here's the thing. It's not just mom who's recovered coming in with DHS going, she's all better. Hey, we know there are termination cases in which the CASA or the child's attorney has opposed termination. All right? So now we got a kid in that circumstance. The CASA and the child's attorney are still parties to the case. It's 6 months later. Now they say to the judge, Judge, we want you to vacate the termination and return the child to mom. Okay? They can do that. Okay? So now the judge is, what is the purpose here? Is the purpose here to save the kid from legal limbo, or is the purpose to give the parents another bite of the apple? Now, I know many of you people believe that judge's discretion means that the judge can do anything he or she wants to do. That's not true. I know some judges who think that's true. And I know all judges wish that was true. But that's not the truth. Judicial discretion means this. The legislature has set a policy goal. And it's a policy goal in the kind of case where you don't necessarily know until you see the case what the equities are. There's no way you make a hard and fast rule. So what does the legislature do? The legislature says, this is what we want you to do. Consider these things, and then do whatever you think gets us to this goal. What's the goal in this case? What's the goal in this case? That's not clear. We asked the legislature for that kind of guidance, and what they said was, well, let's see how it works out. And we'll decide if we need guidance. Okay. So and the reason that I'm talking about it is simply that you're going to see more of this going on. Okay, you're going to see more motions to vacate terminations. Okay, and so that's 414. Any questions? Yes.
Well, I would hope that we have some representation, that we have our attorney in court when that is proposed. I mean, where are we in terms of having some legal representation in these kind of situations?
Well, Linda's going to talk later about the policy option package in terms of the representation. Or you want to say something now?
Well, what I can say is that if there's a case where someone is advocating that a TPR judgment be overturned at a permanency hearing, that would be a contested permanency hearing that falls within the current criteria, and somebody needs to pick the phone up and call an attorney. I don't think it's appropriate to simply go to court by yourself, but I wanted to follow up that, just because there's a TPR judgment in a case doesn't let DHS off the hook of continuing to justify that adoption is the appropriate plan for the child at every permanency hearing until that permanent plan is finalized. It doesn't matter if it's a permanency hearing that Timothy's been describing under this new statute. If the child has been placed for adoption and it's now a year later, but the adoption hasn't happened, that child's still in some care, you still have to have a permanency hearing, and you still have to go through the steps in the permanency hearing statute that says if the plan is something other than return home, you have to show that you're making reasonable efforts to make that final, and then the order has to reflect the court's determination of the plan, and the court has to say in that order, if return home is not the plan and it's adoption, why return home is not appropriate. So a TPR judgment isn't like a pass-go, it lets you off from doing anything that's required in the permanency hearing. So I think there's some confusion here that somehow a termination judgment trumps everything, and you don't have to comply anymore with the permanency hearing statutes. So I hope I'm being clear about that. The permanency hearings, if the judge has changed the plan to guardianship and you haven't finalized a guardianship and you have a permanency hearing, DHS has to justify that the guardianship continues to be the appropriate plan. So whatever plan is in place at the time of the permanency hearing, if it has not been finalized, DHS is under an obligation to justify why a plan higher on that hierarchy isn't a more appropriate plan. Does that make sense to folks out there?
Because again, that's reasonable efforts.
Right. What this bill does, as Timothy's very clearly said, is it simply says that in these few special cases where you have a TPR or relinquishment, we're not going to wait for another year to have a permanency hearing. We're going to do it every 6 months.
Oh, yeah.
Because there is an urgency with getting kids placed in an adoptive placement and getting that placement finalized and an adoption proceeding commenced. So there is a greater sense of urgency there.
Well, I read in the statute that urgency, that we are on top of our plan, that we're working towards our plan. I would argue, with all due respect, in response to Timothy's argument, that the judicial finding of unfitness is the fact that allows the court to immediately say that return is not the plan, that's the factual basis that justifies the finding that return is not possible in the subsequent year. Now, I agree with you completely. It doesn't excuse the agency from advancing the plan and making efforts. But I find it difficult to accept that this modification in the statute creates an opening for expanded attacks at termination judgment.
Well, I
take exception.
And we can talk about that in length, and I know we will. But consider this: not only is the unfitness necessary, so is the best interest of the child. And if you lose best interest of the child, you've lost one of the findings you have to have a termination.
But it doesn't bring you back up.
But we've already had.
But another thing to understand is the legislature, members of the legislature, these very people who are concerned about child welfare cases, they're very concerned about what they call cold cases. Whether we like it or not, the people who make public policy in this state believe that termination of parental rights should be overturned. They would like to be able to have an entirely new termination trial any time. They would like to, on the day that's in the Court of Appeals, they would like to be able to have people enter new facts and new evidence to overturn a termination. That's where this legislature is at. Okay? Now, this whole thing about the Stillman Revolution and all this kind of stuff like this, trust me, that's where they're at. Okay? Now, you may be right, Michelle. You may be absolutely right, and that may be the way that it works out. I mean, it may be the way that it works out. But I'm telling you what the people who wrote this bill intended and what they intend to do with it. So, you know.
So is that going to be communicated to adoptive families?
No, wait, no. Once a child is placed for adoption,
It's done.
once a child is placed for adoption, it's over. You can't do it anymore.
Right, but you understand how adoptive families at the end of the termination trial always feel that, okay, it's over, and sometimes these adoptions with vendor attorneys drag on. And if I'm the parent's attorney, I'm going to be filing for a motion to vacate.
But the parent's attorney is not in the case anymore.
And you can't vacate after the child's been placed for adoption.
That's right.
Once a child is
You got
placed,
to read the motion to modify statute as well, right, Timothy?
That's right.
I mean,
Absolutely.
the motion to modify says you can't modify a TPR judgment if the child's been placed for adoption or an adoption proceeding has been initiated. Which doesn't that say to us, wow, we ought to get those kids in that adoptive placement and designate it too sweet.
Yeah.
Another legal term.
And even if you can't place them,
Because then this doesn't apply. And
Right.
the motion to modify the
Right.
TPR judgment doesn't
Right.
apply.
Right.
It's those kids that are sitting in foster care who have maybe blown out of 2 or 3 adoptive placements, and now they're 13 and running away from home and back to mother every
That's right.
month, that this, I think, has an impact on. It's not the 3-year-old that you have an identified adoptive home, you get the TPR judgment, and that current caretaker is designated the next week. That's not what this is about at all. I mean, that case is beyond setting aside the TPR judgment. Right.
Right.
The legislature talking about best interests, that this is all about best interests of the child, but Stillman is saying you have to prove fitness of the parent first. That leaves me very confused as a caseworker trying to work a plan for these kids.
I think everybody is completely confused about the Stillman thing. But and that's not really what we're doing here today. What we're doing here today is talking about the situation where it's over, and you've got a kid who's not been sort of cemented in by placing with an adoptive home or having a petition. The federal government, by the way, during the CFSR, somebody from the federal government told me that Oregon needs to change its termination statutes. And of course, the federal government has no business telling us to change our termination statutes. But they think, the federal government thinks, that termination ought to be greased. And let me tell you, and I know there are people in this room who think termination ought to be greased, but let me tell you that in the Oregon legislature and on the bench in Oregon, there are people who will tell you that you're not going to do that. And if you think, what's our goal for attaining adoption? 24 months? You know what? Never going to happen. Never going to happen. Not in this political climate, it won't happen. Because the political consensus of the people outside this room is that we don't want to move quickly on terminating. And, whether you agree with that or I agree with that, that's what we're up against. So, okay. And you really got to, yes, go ahead.
I'm just wondering, if a child then is in an adoptive placement 6 months after the termination, you would not be going to this permanency hearing.
No.
But what does it mean, or adoption proceedings?
That means the petition has been filed. Because that's when you
Finalize the adoption?
Yeah.
yes. Yeah, the adoption petition has been filed. Because the adoption proceeding is a legal proceeding that begins with the filing of the petition. Okay.
So does that mean that when they're in their adoptive placement, it has to be designated?
Yeah.
Okay.
The designated adoptive.
Because then it's official.
Then it's official. And you can't do any of this.
Right.
Okay. Let's see. We've got a little bit of time left. Let me real quick I'm going to, because I have to leave a little bit early, let me do a couple of pieces real quick, and then I'll just, whatever time there is. House Bill 2190 is the federal compendium bill. It's on page 15. And House Bill 2190, and the major thing that I want to point out here is the stuff about interstate placement. Interstate placement. The federal government is really perturbed about interstate placement. I know we don't have any problem with interstate placement, I know, but the federal government is really not very happy about interstate placement. They passed a couple of federal laws, one of which is reflected here and the other isn't. The one that's reflected here says that a part of reasonable efforts findings now is going to be a consideration of interstate placement for a child. So if there's a child who the agency is required to look at the option of interstate placement for a child. So if you're looking for a permanency plan for a child other than return home, then you have to do something to look for an out-of-state placement and make some kind of effort, some kind of reasonable effort in that direction. The reasonable efforts finding in the statute now reads that it includes considering an out-of-state placement. The piece that's not in here but that will be in DHS rules soon is the federal government has passed a statute requiring that home studies be completed by a receiving state within 60 days of the time that they're received by that receiving state. Okay? And we have been given additional resources to do those home studies here in Oregon. We have new people working for DHS to do that, and the federal government also is giving subsidies to states to contract with people to do these things. Okay? Well, what's behind all this? What's behind all this is that there is a new ICPC being developed. New ICPC. It won't be called the Interstate Compact on Placement of Children. It will be called the Interstate Compact for Placement of Children, and I'm sure changing that preposition is going to make all the difference in the world. The new ICPC has been introduced, and one state has ratified it so far, Ohio. Oregon, we submitted it to our legislature, and then we pulled it back for various reasons during this last session. There are real problems with the new ICPC. People are unhappy with the new ICPC. It is being revised and redrafted. Okay? But here is some of the problem that Oregon legislators had with the ICPC, people that I talked to. First is that the new ICPC requires that when 35 states pass it, the administrators from those states will get together and they will write new interstate placement rules. Okay? And then a year after the ICPC is passed by the requisite number of states, the old ICPC dies. And a state that has not adopted the new ICPC then has no means to place children out of state. We are, by the way, by far, a net exporter of children. By far, we are a net exporter of children. If we're not on the ICPC bus when it leaves, then we have no way to place children out of state. And also private adoption agencies have no way to place children from out of state, nor in-state, by the way. Okay. Legislators don't like the idea that some, what they would call bureaucrats from a bunch of states are going to write these rules, because these rules, by the terms of the ICPC, would overrule Oregon statutes that are contrary to them. Okay? They don't like that. That's sort of a barrier to them. The other thing is that there are some financial requirements in terms of setting up a database to track all this stuff, and they can't really tell us how much that would cost. Going to the legislature and asking for a blank check is really not a good idea. I've been working there since the early 90s. I'm here to tell you, don't ever go to the Oregon legislature and say, we want this, give us a blank check. They won't like it. Okay. So, but the ICPC is something that is definitely in our future. Right now, the Court Improvement Project is doing an assessment of the functioning of interstate placement in Oregon, and we have to have recommendations by June for improvement. We're going to hear a lot more about this coming up. Okay, that's House Bill 2190, and I think I'll just give the rest of my time here, such as it is, to y'all and see what y'all want to do with it.
Okay. Well, I'll make a couple of comments about 2190 before I can get off of that. Just actually two things. There's a list of federal laws, as Timothy mentioned, in that bill. We're not going to cover all of them. There are also federal laws that pass that are not in that bill, but will appear in administrative rule. And for DHS staff, Harry Gilmore out of Central Office is the point person for that. So if you have questions, you can call Harry. Two things I wanted to mention in the federal law. The opt-out that we had for ASPA was repealed. We no longer will be able to have an exception on an ASPA crime beginning October 1st of 2008. So we have about another year, and then we'll lose that exception ability, and that's a federal law that was implemented. Yes?
So that means the kids who are in placements on those exceptions will have to be moved?
No, it's not a retro thing. Thanks for clarifying that. The other thing I wanted to mention is around face-to-face contact. The federal law apparently says that face-to-face contact is required once every 6 months for a child in foster care. In Oregon, we see a child once every
30 days.
Thank you. That was DHS, I can tell. So the way that this works with the ICPC that Timothy was talking about is if Florida sends a child to Oregon, the caseworker in Florida will say to our caseworker, I need you to see that child once every 30 days. And we'll say, well, in Oregon, we're going to see that child, once every 6 months. And we'll say, I'm sorry, but in Oregon, we'll follow our policy, which is once every 30 days, and that's fine. If the Oregon child goes to Florida, we expect the Oregon caseworker contact the caseworker in Florida and say, we would like you to see that child every 30 days because that's our policy. The state of Florida will say, because we're privatized, we only have to see that child once every 6 months. I'm sorry, that's all we're going to do. We say thank you, we document it, and then that's fine. But we need to make the effort to try to get them within our policy wherever we send children. Yes, Barbara.
So I want to go back to the placement of relatives in ICPC. Is there any movement to have some kind of regional reciprocity? We have so many relatives in Vancouver. We've got grandma in Vancouver. And we talk about the placement of relatives. We can wait to grandma, but we can't get that child over there in a reasonable time.
I think Timothy has something to say.
For about 10 years now, you and I and everybody in this room have heard about border agreements. Right? We're going to have a border agreement with Washington, right? How many of you believe we're going to have a border agreement with Washington?
I so want to.
I do too. And the reason I believe it is, there's two reasons I believe it. The first is that I talk to Harry Gilmore very regularly, and there has very recently been some change of personnel and some change of attitude in the state of Washington around a border agreement. I think it's going to happen. The second reason I think it's going to happen is that having that border agreement, that's going to be part of what my assessment finds out about the functioning of interstate placement in Oregon. And so working that border agreement is going to become part of the court improvement project. We're going to be setting up some meetings with judges from Washington and judges from Oregon, and some meetings with Harry and his counterpart in Washington in the court improvement, and we're going to get together and we're going to all do what we can to get the border agreement. So I have faith that we're actually going to get it. Not tomorrow, not next week, maybe next year sometime. But I think we're going to get that border agreement. But there's no movement under the ICPC to automatically have reciprocity. We still have to meet the basic ICPC requirements. There's no waiving of home studies. There's no waiving of home studies to send them to parents or all this other kind of stuff like this. So, okay, I got to go. Thank you very much.
Let's say Florida says every 6 months, but us as caseworkers, are we required to call that caseworker every 2 or 3 days to document their case, come up and say they won't see it?
Yes.
Versus the cost is one thing.
Yes, we would follow our policy, which is every 30 days.
So call that caseworker.
So we have to call that caseworker every 30 days.
I would
and tell them.
think we'd want to document that we've made some effort to meet our policy on that. I mean, even if they're saying, there's been no change since the last report. I think that's a good plan. Or an email.
Yeah, that'd be better. I mean, just for us to keep up with all that, just given our workloads is a lot.
But you don't get to go to Florida.
Yep.
Sorry.